Amaka Co. presents Law Simplified.
Every legal question deserves a clear answer.
Now, let's look at today's topic. Your entire case could end before the judge hears a single witness. He believed he had evidence. He believed he had the truth. He believed that was enough. The objection wasn't about the evidence or even who was telling the truth. The issue was something many Nigerians have never heard of, yet it has ended countless cases before they truly began. It's called capacity to sue and be sued.
Imagine losing a loved one, then discovering someone has taken over part of the family's property. Most people think the next step is simple: go to court immediately.
One common mistake is assuming that because you've suffered a wrong, you automatically have the legal right to bring the case yourself.
In many situations, the court first asks a different question. Do you have the legal capacity to bring this case? Without that, the merits may never even be considered. If you're bringing a case on behalf of someone else, for example, as the executor of a will, an administrator of an estate, a guardian, or any other legal representative, that capacity must be clearly stated in your court papers. If you're acting for a community association, church group, market association, or another organization, don't assume it can automatically sue in its own name. In many cases, that depends on whether the law gives it that right.
The law is settled that a deceased person cannot sue or defend a lawsuit. In most cases, the proper parties are the legally recognized personal representatives of the estate.
Children also require special legal protection. In most cases, they do not sue or defend court proceedings personally. The law generally requires them to act through a guardian or another legally recognized representative.
Using a business name doesn't automatically shield you from legal action. The law may still allow proceedings to be brought against a person trading under that name. Here's another rule that surprises many people. Even if you're a shareholder, a wrong done to the company is usually a wrong done to the company itself. In most cases, it is the company, not an individual shareholder, that should bring the action, although the law recognizes limited exceptions. Experienced lawyers rarely begin by asking only what happened. They first confirm who has the legal right to sue, who should be sued, and whether every necessary document is in place. If your legal capacity is challenged, simply saying you have the right to sue may not be enough. The law may require you to prove it with the appropriate evidence.
Many people don't realize this. The issue of legal capacity can be raised at any stage of the proceedings, even on appeal.
The law doesn't simply ask whether you have a complaint. It also asks whether the right person is before the court. That single question can determine whether your case proceeds or comes to an abrupt end. This is why lawyers often describe legal capacity as a question of jurisdiction. If the court finds that the proper party is not before it, the case may be struck out before the evidence is ever examined. Strong evidence cannot always rescue a case that began with the wrong party before the court. Sometimes the first legal mistake becomes the last.
Winning your case isn't just about the facts. Sometimes, it's about whether the law recognizes you as the proper person to bring it. A few careful legal checks at the beginning can save months of frustration, unnecessary expense, and avoidable delays. That is why understanding legal capacity is so important before any court process begins. Before you file a lawsuit, defend one, sue on behalf of someone else, or commence proceedings involving a company, an estate, or an organization, understanding these principles could save you significant time, cost, and frustration. To read the full article on this topic and to explore many more practical legal guides, visit www.amakaekelawoffice.com/blog.